I'm here with Don Moll, who is also known as the divorce mortgage guy. We're talking about mortgages in the divorce process and kind of looking at some things you need to think about, look at some of the pitfalls and so on. So, Don, thanks for joining me today.
Thanks for having me.
Yeah.
This will be fun.
So first of all, let's talk about, what the home represents for people, right? Like when a couple decides that they don't want to be in a relationship anymore and decide to get divorced, especially if there's kids involved, the home is often a very emotional topic,
Mhm.
right? And often staying in the home or keeping the home can be kind of a priority, right, for somebody going through divorce. So what would you say to that as far as, how realistic it is? What are things people need to think about early in the process and so on?
Right. And I understand that full well, that it's not just, four walls and a roof. It's a home.
Right.
And there's children, their friends, the schools, the stability, et cetera. So yeah, it's more of an emotionally driven aspect of the whole process. And we do have to take a step back and take a look at what are the finances of it. And it's not necessarily just I've got a mortgage payment, but it's also understanding that there's certain holding costs associated with the home that goes beyond making your mortgage payment and any escrows for taxes and insurance. So I always try to kind of just sit back with when I'm in a consultation with a client, just saying, okay, what other of these other expenses associated, things that you don't think about. What if you have a pool? And what's the lifespan? Every pool pump, for example, has a lifespan. What if that thing's 10 years old? Okay, and you're gonna have to replace it in 1 or 2 years. Well, that's thousands of dollars that goes into the upkeep of a home. What does it cost to pay those people that are maintaining your lawn or the landscaping? There's expenses associated there. And also, one thing in terms of the home itself, many times I'll come into a case and they'll maybe have had a marital appraisal done on the property just to kind of say, okay, what's this worth? A couple issues with that, but one is that what people don't have to understand when that appraisal is done, it's basically for one reason, and that is to predict the loan performance, meaning whatever bank is going to be doing the mortgage on that, they want to make sure that that home is sufficient collateral for the proposed loan. Here's the potential issue, and this is what's happened, where the appraiser is not going to, they'll tell you, we're not getting in the crawl spaces and going up in the attic and that. They're just making sure that that collateral is sufficient. I always recommend having an inspection performed.
Okay.
Because, perfect example, was working with a couple, because I'm all over the state. This couple was in West Palm, and the couple had suffered some roof damage due to one of the hurricanes during the marriage. Well, fast forward, they get divorced. They had an appraisal done. Well, once, as luck would have it, the marital settlement agreement was signed, then the wife, she kept the home. She noticed some stains up on the ceiling. And as it turned out, that they had done a do-it-yourself repair on the roof. Well, not only did a do-it-yourself repair not work, but now there was a black mold issue.
Oh gosh.
And that's $20,000 to $30,000 to repair. So that was an expense that occurred during the marriage that appraisal didn't pick up. So that's why I say
once the marital settlement agreement's signed and that home is now hers, there's really no recourse there.
It's done. So that's why I always, from a holding cost perspective, I always recommend get that inspection. You had an inspection done when you purchased the home.
Yeah.
Do it on the back end as well, because you just never know. And they're going to identify those things, like I mentioned, like the pool pump, for example. They're going to identify that just so you have an idea. And that helps in the negotiation of, is what, you and I are all about option building, So it's just something to identify.
So how do people figure out whether it's realistic for them to keep the home? And like, when do they bring somebody like you into this process, right? Like, let's say they're just, is it just starting out the process? Is it towards the end?
During the negotiation process, because once that, you mentioned it, once that marital settlement agreement signed and we have a final divorce decree, there's not a lot that someone like me can do on the back end. And that's that even when I do a lot of my continuing legal education credit lectures across the state, I tell them, look, when what you think is a legal option, you submit your documents to the judge in your family court. By the time it gets to someone like me and we submit it to our judge, who's the underwriter, our underwriter is going to say that language is conflicting with what they're trying to do, which is either do a refinance or an equity buyout of the home, or even if they're going to purchase a new home down the road. So it's vital. In fact, right now, I have 3 cases that come to mind that they came to me post final judgment. All 3 of them they come to me prior. There would have been some language that I would have gotten into the marital settlement agreement that would have enabled them to do what they want to do, which was equity buyouts. All 3 of them, and it's not the end of the world. There could be an amendment done.
Right.
However, all of the 3, 2 of the ex-spouses said, we're not going to do any amendment. We're not signing anything because we're done.
Yeah, that's what I was about to say. You could do an amendment if the other person's willing, right?
2 of the 3 said
the asterisk.
no.
Yeah,
And I've been there, and I know, but once you're done, you're done. You've checked out. So you're in that zone for a while, and then you want me to revisit this thing? No.
Right.
Yeah. So yeah, definitely the earlier on the better.
And you mentioned a few terms there, right? So like when most people, their home's their biggest asset. So this is, a big deal, right? Trying to figure out how are we going to resolve this, especially nowadays where the interest rates for a lot of people might be significantly higher if going into a new loan than they were maybe when they purchased the home, right? So what are the different options people are usually looking at, right? When they're looking to either carve up a mortgage or so on, and what is realistic for most people?
Well, what's big right now is I'd say now the last 18 months, because during the pandemic, we had an unprecedented period of historical lows in interest rates. And if people weren't living under a rock, they were refinancing their rate to the 2s and the 3s.
Right.
Well, fast forward now, we're at now more historical norms. People say, oh my God, it's 7%. So, well, a little perspective. We're what, June 13th of 2024. If we were to go back to June 13th of 1974, a 50-year period, which is a more of a realistic time frame. The average 30-year rate is just under 8%.
Right.
So it's just, let's keep things in perspective. But with that said, I wouldn't want to go from a 3% mortgage to a 7% mortgage today. So loan assumption has been big. And whenever I do a consultation, I say, hey, listen, here's what your landscape is and your options. And I call it door number 1, door number 2, and door number 3. And behind door number 1 is their current spouse. And so what I would always tell them is you want to ask your spouse, whether you're on the mortgage or not, if you can assume the responsibility for making the payments on that mortgage. And that's the path of least resistance, because that loan doesn't have to be modified. Nothing, the servicer doesn't need to be involved. And so typically your spouse is going to have one or both of the following objections. One of which is going to be, I'm not going to be able to qualify for new mortgage financing as long as I'm tied to this, because my debt to income ratio is going to be too high where I won't be able to qualify. And as Lee Corso says on College Game Day Saturdays, not so fast, my friends, because as long as there's language in the settlement agreement assigning the responsibility to the spouse wanting to retain the marital home, when the vacating spouse goes to apply for mortgage financing, that payment will be removed from his or her debt to income ratio, because it's now considered a court-ordered assignment of debt, or what we call a contingent liability in the mortgage industry. So from a qualification standpoint, it will not harm him or her for qualifying.
So basically what you're saying is even if their name were to stay on that mortgage, technically, as long as that language in the MSA is correct in assigning that debt to the other spouse, it won't actually affect their ability to purchase in the future.
From a qualification standpoint, it will not impact them negatively.
This is why people need to talk to people like you early in the process, because that changes a negotiation significantly, right?
Oh, sure.
People understand how this works.
Sure. And it's not common, because the second objection that vacating spouse is going to typically have is, well, if you're not timely with your payments, my credit score is going to go in the tank, or if you default, I'm still legally responsible. And that's true. And
Okay.
so there is some one way to overcome that, and that is if the vacating spouse is maybe the payor of alimony. I've
Right.
seen language where they'll say, okay, mortgage is due on the 10th. That vacating spouse can go in on the 8th to the mortgage website. If it hasn't been paid, make that payment to protect
Their
his or
credit.
herself, and then give themselves a credit for the ensuing alimony payment. That's one way. But that's the what's called the simple assumption. In fact, yesterday I was in Tampa giving a CLE to a law firm. And one of the attorneys said, well, hold on, what if they do a transfer of title? And so if the title is recorded, what can happen? The bank can come in and say, well, hold on, that's a transfer of title. We didn't agree to that. So we can accelerate what's called the due on sale clause, or you call it a balloon payment, saying pay up. Well, typically that'd be the case, but back in 1982, there was a piece of legislation passed, and it's a mouthful. It's called the Garn St. Germain Depository Institutions Act. Say that 3 times real
Oh
fast.
my gosh, yeah, that's
And what it what it did was it created transfers of property that are exempt from banks being able to enforce that due on sale clause.
which is
So
including
the
divorce.
two most common times are inheritance. So think mom and dad have a piece of property, they pass away with a
Right.
mortgage on it, kids can make the payments. Or the second most common time is if the successor of interest is incident to divorce, in our case,
Yep.
then they're offered the same protection. So those are some misconceptions with that type of a loan assumption that, it's just without knowing, you don't know. So that's that door number one. Oftentimes that spouse says no, which is understandable.
Yeah.
So then door number two, behind door number two is their current mortgage servicer. And again, if they have a 2 or 3% interest rate, I always tell them, look, I want you to call the current mortgage servicer. You're going to ask them about the qualified loan assumption package. And what your servicer will do is qualify you as a sole borrower based on your credit worthiness and financial ability to repay the loan. Now, I also want you to use these words when you call them. Say, I want you to honor the current terms of the loan, including the rate. And it's when I say current terms, they can always throw, well, we'll honor it, but we want 5% more equity, or
Right.
we're going to charge X amount of discount points. And when it comes to the rate, I always tell them, expect a polite chuckle, because from a business standpoint, why would they refinance you at 3% when they can sell that same piece of paper for 7 today? But it doesn't hurt to
Right.
ask. And I've had
You know
multiple.
what? It doesn't hurt to ask, because I just had a client recently ask and they said yes. So you just never know.
You don't know.
Yeah.
So all they can tell you is no.
Right. And then you're at the same, so you may as well try, right?
You got it. You got it. So those are the two, when it comes to loan assumptions, those are the two. So you got the simple assumption, and then you got the qualified assumption.
So the assumptions are one option, and then obviously then refinancing. I think most people understand how refinancing works, but in a divorce process, right? Like if somebody, let's say both spouses are on the loan, both spouses are on title, which is often the case, right? How would that process work from a refinancing standpoint? Do they usually refinance with the same bank? Would they look at multiple banks? Would they talk to someone like you and run numbers? Like, how would that go?
Well, there's a refinance and then there's an equity buyout.
Okay.
So and that boils down to how that's negotiated within the attorneys. So let's just say for round math that they have a $100,000 mortgage balance on a $200,000 valuation of a home.
Okay.
So there's $100,000 of equity there.
Mm-hmm.
So if the vacating spouse says, just get me off the mortgage, I don't need my equity, then that's just a straight up refinance. They're going to either do it with the existing lender or do it with someone like me.
Mm-hmm.
If the vacating spouse says, no, there's 100,000 of equity, I want my $50,000,
Mm-hmm.
that's called an equity buyout. And that again is a refinance, but there's 2 different ways to do it. And the way that we structure it as CDLPs is that we get language that we need so that we can structure it in such a way that is bottom line going to be able to access more equity in the home and actually have better financing terms. And that's just because of how we've been trained and the knowledge and the experience that we have. So that's the difference between a refinance and an equity buyout.
Okay.
And they can do it either through their current lender or again, another lender like me.
let me ask this, because I think this is a big question a lot of people have, right? A lot of times there may be a household, like a family structure where one parent works, the other parent doesn't work. Parent who doesn't work maybe wants to keep the home. How does child support and alimony factor into this conversation?
So we use support income, whether it's child support or alimony. And what people have to understand, including attorneys, including judges. I had 3 judges come up to me after I gave a CLE lecture, and they said, one of them said, I give her credit. She said, I realized after attending your lecture about that support income, I had just signed off on orders that morning, and now realize that there's no way the wife is going to be able to effectuate that equity buyout. So what we do is we call it the 636 rule. Meaning this, that if we're going to use, whether it's child support or alimony, we need to have 6 months receipt of support income payments as ordered before we can even initiate any kind of a mortgage application, whether that's for doing a refinance of the marital home, an equity buyout, or purchasing a new one. And then once we have,
nothing's ordered until final judgment, right? So
correct. And it's funny.
So that, which people, for example, you could sign a marital settlement agreement, and then it takes a few months for the judge to actually sign the final judgment. And so then 6 months from then of alimony payments to even qualify to be able to start that refinancing process.
Correct. And what we do many times is we can start that 6-month clock prior to final judgment by getting temporary orders. So temporary orders are, so people will say, well, you know, he or she's been paying me, you know, X amount voluntary payments. Unfortunately, those don't count in the eyes of the underwriter. It's got to be a court order. So temporary orders is very simple to get. So that'll start that clock. So once we're able to show underwriting, okay, the payor has made those payments as ordered for 6 months. Now we can initiate the mortgage application. But then the underwriter is going to say, well, before I even go down that path, I need to see documentation that those support payments are going to continue for a minimum of an additional 36 months.
Okay.
So thus the 636. We need 6 months on the front end before we even start the mortgage. Then we need to show that those payments will continue for 36. So for example, if we have a child who's 17, well, those payments are going to continue for 3 years, because typically, unless there's extenuating circumstances, those payments are going to cease at the age of 18.
Right. But alimony, right? So alimony could potentially continue longer and be considered, right?
Alimony could. Now, interestingly enough, last July 1st, we had an amendment to the durational alimony. And what they did was they now consider a short-term marriage is greater than 3 years or less than 10. And then the starting point, because it's negotiable, but the starting point is 50% of the duration of the marriage. So why do I say that? Well, at CERT review this year, Charles Fox Miller was the one that spoke about the alimony reform amendment, and he made a comment that really caught me off guard. He said that the majority of divorces are filed within 7 years, or the average marriage lasts 7 years. So if we go back to my 636 rule, if we have I need a minimum of 42 months.
Yeah. Right.
And the marriage is less than 7 years, we're not going to have 42 months. So that's where it's getting someone like me involved, saying, hey, listen, maybe we just structure that award amount maybe a little lower, but for a duration that's going to be sufficient for qualification for mortgage purposes.
Yeah, see, people don't know these things, and this is what gets somebody. You think you come to an agreement in theory, right? You sign it all, but then can that agreement actually translate into, you know, reality with the mortgage underwriter? And that's two different things. And a lot of times that second part gets lost, right? Because it's so hard to come to those agreements to begin with a lot of the time.
And then we're dependent upon the payor to make those payments as ordered. So if you have someone that has maybe fluctuating pay or unstable income, and let's say the order states there's $1,000 due on the 5th of the month, and the payor says, well, I'll pay you $500 on the 5th, and I'll pay you $500 on the 15th, or I can't pay you this month, but I'll double up next month. Underwriting is going to reject that, because they're going to look at that, says, what is the order state? The order state's $1,000 on the 5th, because what they're going back to is the consistency and stability of that income. And if that's not consistent and stable, they're not going to prove it.
Well, so that's good for people to know in cases like that. If there is like an unstable income, that you're better off doing a weekly payment or a bi-weekly payment that's lower, that's going to be able to be maintained consistently than to try to
Yeah.
adjust it later.
And underwriting doesn't care when it's just whatever the order states,
Just has
you
to.
better be able to check those. You got it. You got it. And it's even, get out. Underwriting can be a little nitpicky. And I say that because, for example, we had a case where he was to pay $9,500 a month.
Mhm,
And this was during temporary orders.
mhm,
So he paid $9,500 a month, but from that amount, he was to pay the mortgage directly. He was to pay the utilities directly, and then he was to pay the children's medical expenses, and then net out from that the rest to her.
yes, right.
Well, she went to apply for mortgage underwriting, and the underwriter said, "Well, hold on, this alimony payment award has been all over the board because it's not a consistent, stable amount, so they couldn't use it." So
They
that's
would have
when
been
we,
better off just having him pay her the 95 and then she paid out all the other stuff.
yep, yep,
Yeah,
yeah.
that
And
is
there's
true.
other aspects too that you don't even think about. I always ask to look at the homeowner's insurance policy.
Mhm,
And the reason is that this is more common than you'd think, where, in fact, it was just in November, and then I had one again in February, where the name insured was, in both cases, I was working with the wife, the name insured was the husband.
mhm,
Well, here's the potential problem. And this was a case in 1982 here in Florida, where a couple was getting divorced. She was going to be vacating the home. She was the named insured.
mhm.
They got divorced in August. Fast forward to November, a fire destroyed the home. He filed a claim with the insurance carrier. Carrier said, "Well, where's Mrs. Smith?" "Well, that's my ex-wife." Claim denied.
Right.
So it's an easy fix. I always
Not
advise, that's
married
why I
to him
asked for that.
anymore.
I
Yeah.
always ask to see that policy. I'm like, just to make sure. And by the way, it's take a breath. It's an easy fix. I want you to call your insurance agent. I'd also recommend calling your carrier. Just
Yeah.
be named as a named insured or added as a named insured prior to final judgment.
Right. And then you're there no matter what.
Yeah.
Well, and one question I would have is that I think a lot of people might have is this temporary order, right? Like especially if you are in a highly contested divorce, right? Like two people are having a really hard time getting on the same page. Um, and alimony is often, not always, but often the hardest agreement to come to for
Mhm.
people. Okay. It's usually the last thing that's kind of out there. So the idea of agreeing to a temporary order for alimony might be really difficult because a person might say, well, I don't want to commit to that because we haven't negotiated everything else. So what does that look like as far as changing that amount later? How does that impact that process?
Have you sat through one of my CLE lectures? Because
I have, and that's why I'm asking because
you asked the perfect questions.
I know the answer, but I want other people to know the
Well,
answer.
no, I'm blown away because these are things that people
I
don't even think
remember
about.
I put that one in my long-term memory.
So when it comes to the temporary orders, that is a valid concern. Well, what if that final award amount is different? That it doesn't matter. As
Okay.
long as whatever, let's just say the temporary award, I'll pay $1,000 a month.
Hmm.
Fine. And then when the final award, let's say it's 2,000. Okay, great. All we need is 1 month of that final award amount, and then we can initiate the mortgage transaction. And we've had time served for the previous temporary award order amounts.
Okay, so then somebody, let's say two people are having a pretty heated battle over the alimony. They can't come to terms. She wants 3,000, he wants to pay 2,000 or 1,000 or whatever. So he could agree to pay 1,000 temporarily just to start that clock. And then
Mhm.
if they come to agree to two, let's say, um, if she gets 1 month at the 2,000, then the underwriter would look at the 2,000 as her available income, not the one,
Correct.
because that would be the final order that the judge would sign off on.
And that would be the qualifying
Income.
income that we would use, right?
Okay, yeah. See, that's all really important information. I think that, why people need to call somebody like you
Oh,
uh, early in the
no.
process.
And speaking of, say valuation, I'm just now going back to the house, and speaking of marital appraisals,
Mhm.
I've seen this happen. Where they say, oh, Don, we've already had a marital appraisal done. Well, if one of the spouses is going to be retaining the home and there's going to be an equity buyout,
Mhm.
then the only appraisal that can be used is the one that's ordered from the bank.
Right.
And where that can present problems is, let's say they have a marital appraisal, and let's say the appraisal comes in at $500,000.
Mhm.
It's written into the marital settlement agreement. They sign the marital settlement agreement, and then the spouse maintaining the home goes and speaks to a lending bank. They order their appraisal, and it comes in at 575.
Mm.
Well, that loan amount with that equity buyout is going to be based on the 575, not the 600,000 that was written in due to the marital appraisal done. Now you're gonna have a problem. So
Right.
that's when I always say, listen, if you know that one spouse early in the process is going to want to, you agree, one spouse wants to maintain the home, get someone like me involved now. Go ahead, order that appraisal. So all parties are working off the same valuation, because ultimately, if that spouse wants their equalization payment, it's going to be coming from that appraisal report, not the one you have done by somebody else.
Right. Yeah. The only workaround I could think of is if people were willing to agree to a flat amount because they feel pretty confident it's going to be within some sort of window. But that wouldn't be a true 50-50 as long as they've both in agreement to do
Right,
that. That's an
right.
option. But most people want to end up at that 50-50. So the only way to do it is what you're suggesting.
Yeah, ultimately, and I'll get pushback. Well, bank appraisals are historically low, and that's just not the case. When we order an appraisal as a bank, because we're an independent mortgage bank, and we hit the button, or any mortgage professional for that matter, hit the button to order an appraisal, it goes into call it a national round robin system. They're independent appraisers. They're not employees of the bank.
Right.
So there's no skin in the game for that appraiser. It's their professional reputation if they come up with a fair valuation, not because the bank or one party wants a particular value coming in. Those shenanigans I know happen maybe in
That's
like,
more like the private appraisal. That's when you kind
yeah,
of hire somebody that's a friend and so on. But even
right,
so, again, they're held to a certain ethical standards. So like they can't just be going around changing appraisals to whatever they feel like, or they wouldn't be in business very long, right?
right.
So, there's
Or or the other way to you get the valuations from a realtor that can prepare the comparative market analysis, or CMA.
right.
So
But at the end of the day, that equalization payment, regardless, is going to have to, if they're trying to pull equity out of the home, they can only get as much equity as that appraisal is going to allow for, right? Or the loan's going to allow for.
bank
So,
owned appraisal, you got it.
right,
You got
right.
it.
Okay, so what else have we not thought about in this conversation, right? Like, is there anything that people should be aware of, aside from alimony and child support that they need to be thinking about?
I yesterday I was driving home. I think I was in Tampa, and one of the forensic CPAs I work with said, "Hey, do you have a minute for being in a mediation?" I said, "Yeah, if you don't mind me being on speakerphone and you hear the rain, crashing down the car."
Right.
And the party so it was a wife that was looking to maintain a home,
Mhm.
and she had left the workforce. I think it was 6 months ago.
Mhm.
And then she said, so I don't think I'm going to be able to qualify for at least another, if I'm looking for a job, if I get a job another 6 months. I said, well, what did you do prior?
Mhm.
And she said, well, I was in HR consulting for about 15 years.
Mhm.
Well, are you going to be getting back in that same line of work? She said, yes, that's exactly what I'm doing. I said, okay, well, that's not going to be an issue, because as long as we can build a bridge, a 2-year bridge prior. In fact, another client I worked with, she's an attorney, and she had been a practicing attorney, left the workforce to be the primary caregiver for the
Mhm.
children. Now she's going back to work. Well, we can build that bridge and utilize that income right away. Whereas maybe, and then I was working with somebody who
You're
was
saying basically the moment they become employed again, you can start from day one versus starting a clock, kind of? Is that what you
sometimes, but maximum six
mean?
months. But typically, if we can build that bridge, then there's many, many occasions we can start right away.
Okay.
Um, But for example, another one I worked with, she was a hairdresser, left the workforce to be the primary caregiver. Then she was going back to work. She was managing a doctor's office.
Okay.
Now, two
That's
different
very different.
underwriting won't accept it.
So then in that case, they'd be looking at how long before she'd really be able to qualify.
Typically 6 months.
Okay.
Yeah.
Yeah, but I mean, that's good information for people to be aware of for sure. I mean, I think it's pretty clear from this conversation that people need to be calling someone like you, the divorce mortgage guy, right? To get
Thanks for
to
the plug.
get some advice. Yeah, so certified divorce lending professional, that's your official title, right?
Well,
So
and you know, it's not just as easy as, believe me, my number one, I guess, goal is to go around the state and just educate folks that there is a difference between your traditional mortgage professionals and a divorce mortgage planner,
right.
and creating awareness that there isn't such a thing. Because it's not just go talk to somebody, get you qualified, because we have so many other aspects. You know, what if there's a 401k involved? Maybe one of the spouses has a 401k. Now they've got to, because typically the two biggest assets on the marital balance sheet are the home and a qualified retirement plan. So then they're going to have to get
I
some.
guess that's a question that I have now too, that you brought that up. What about like retirement income, right? So like if people are of that age bracket where they're pulling, distributions out of their retirement funds, how does that factor?
If they're post 59 and a half,
Mhm.
then yeah, that's going to be income that can be used for qualification purposes. But if they're pre 59 and a half, traditionally you can't.
Right.
But again, where our training kicks in is there is a strategy where it can actually potentially use that for qualification purposes.
Okay.
Again, but it's key to get involved. There was a financial advisor in, I think, Boca, who
Mhm.
called me a couple months ago. She said, "Hey, I'm working with this wife. We just received the transfer in of the proceeds from they have to get something what's called a qualified domestic relations order, or a quadro.
Right.
So you got to get the quadro before the fiduciary, let's just call it Fidelity, can release those
Mhm.
funds." So she said, "Yeah, we just got it today." I said, "Okay, great." I said, "Please tell me you didn't roll it over to another self-directed or some sort of an IRA qualified plan." She goes, "That's exactly what we did." I said, "Oh no." We just shut the door on an opportunity to use that as a qualifying asset. So that's where it's key that, like, going back to your question, when do I get involved? Have to get involved early, because otherwise, because it's not just the attorney, there's other members of the professional divorce team
Right.
that make sure that we're all effectively doing our job. Because if we're not talking to each other, then that's a perfect example where it's like, not a lot I can do right now.
Mm-hmm. And what about trust accounts? How do those factor in? If someone, let's say, obviously a lot of times in divorce, there could be trusts that get distributed. Um, how does that all play in?
Yeah, so I talked about employment income. There's guidelines I've got to follow. So there's employment income guidelines, there's support income guidelines, and then there's trust income guidelines. And we have a strategy that we'll employ many times where, speaking of alimony, ever since the Tax Cuts and Jobs Act of 2016, any marital settlement agreement signed on or after January 1st of 19, there's no longer a tax benefit for the payor,
Right.
monthly support, monthly alimony. So if they have the assets, we've seen a lot of just, here's a lump sum settlement award. And okay, great. If we're working with the spouse looking to retain or marital home or buying a home that now has this lump sum, got a fat bank account, but you don't have any income, and you kind of need income to qualify. So there's different strategies that we can do with that, but there is a strategy where we will utilize trust income to qualify. And again, that goes back to where I have to be involved early on in the process, because there's specific language that's needed in both the trust and the marital settlement agreement to get that to work.
Okay.
But yes, it's very effective. In fact, when I was in the downpour, that's the one strategy yesterday. That's the one strategy we're actually going to do with this spouse.
So there's usually some sort of workaround, but if you're in the conversation early,
There's
the blanket
yeah,
answer.
yeah.
Don't bring me in too late.
In fact, and it's not everyone that knows. There was This woman was in Daytona Beach that I come to think of it. She had talked to her traditional, mortgage professional, and they said, okay, we got to structure it this certain way. And which is the way we're all trained when working in divorce. So she came to me and she said, my attorney said to call you because he thinks you can do it another way where we can get more. And I said, yeah, there actually is. So I structured it the way I needed to structure it. Went to my underwriter. My underwriter pushed back. I said, no, here's a guideline. You can do it. Okay, so they approved it. Now it goes to the title attorney. And it was an FHA loan, which means it falls under the U.S. Department of Housing and Urban Development, or HUD. And so he came back and he said, HUD's pushing back on it. They're saying they're not going to approve it because you have it structured as this type of a loan. I said, all right, let me get to my office. I'll send you an email. Send him an email with FHA and HUD guidelines. He called me and he said, is this right? I said, yeah, just submit it, see what happens. A week and a half later, he sends me an email. I guess HUD is in Oklahoma City and they approved it. So if HUD and FHA don't even know their own guidelines, there's a high probability that your traditional loan officer won't know the guidelines either.
Right.
So that's why, again, whether it's myself or another, there's just under 10,000 licensed loan originators in Florida. There's 28 of us. So whether it's me or somebody else, I can't emphasize the difference, because it's either that or you got to sell the home, and that's, I tell you, that is a call I dread making, especially when there's children involved and I got to call back and say, can't help you.
Yeah.
I take that to heart.
Well, especially when there could have been a solution.
Yep.
Had you just been in the conversation a couple months prior.
Yep.
That's tough. Thank you for all this information. I think this is super informative for a lot of people. How do people find you if they want to reach out to you?
It's pretty difficult website to remember. It's the divorcemortgageguy.com.
I like it. All right. So Don, thank you so much. Really appreciate it.
Thanks for having me.
Bye-bye.
Bye.